you going to stand on your brief?
I'll stand on my brief.
All right, sir, thank you. All right, the court will call the next case then, CHUBB Custom Insurance Company v. UT Investments, LLC.
May it please the Court, Carolini for the appellant, CHUBB Insurance Company. I'd like to reserve 5 minutes for rebuttal, please. This case is about 2 stipulations and a judgment that was entered in favor of the insured because only one of those stipulations was honored. And it's also a case about a judgment that was erroneously entered when there was undisputed, unrebutted evidence that a certain amount of payments had been made on the building claim. And just a little bit of background. This entire case was about additional payments that were allegedly owed under an insurance policy. There were previous payments made under the insurance policy, and those payments were recorded by the parties in their joint stipulation prior to trial. The parties proceeded through trial. They get to the end of the case. The jury entered a 0 verdict, no additional payments, no additional damages, and because of a stipulation that was entered into trial by counsel as to a scope of damages for certain rooms called the fire rooms, UT, the plaintiff, demanded judgment in their favor.
Let me ask you this. Looking at the stipulation of counsel, where it says the insured has presented a claim to CHUBB Insurance Company for a loss to the building in the amount of $1,030,349 and some change. CHUBB has paid the insured $371,455. Was there any question going into this trial and working on the joint stipulation that $371,455.76 was the amount CHUBB had paid towards the damages?
There was no question, Your Honor. In fact, that $1,030,000, the estimate for UT, that was strictly for the building. And then the $360,000 estimate, which was, there was a number of estimates, that MK estimate, it was undisputed that that was strictly for the building. So the $371,000, CHUBB Insurance Company thought, we've reached an agreement, as you should. Rule 1.200 requires the parties to get together and try and narrow the issues to be tried. So the previous payments were never at issue. And this entire appeal, the only opposition that the plaintiff has to our appeal is that there was one fact witness who did not identify certain checks that made up that payment on the building. And we submit that is error.
That was the $50,000 check?
Yes, Your Honor.
Right.
And if you notice in UT's brief, they only reference the detail section of the check that says advance on fire loss. They never point out the fact that on both the $50,000 check and the $185,000 check, it says ahead of that type of payment, semicolon, settlement 5101, building. These were joint exhibits admitted in front of the jury without objection. And again, it wasn't, the jury trial was about additional payments, not previous payments. But nevertheless, if we're talking about set-off, that was tried by consent. And both of those checks contain that identical information. And we did argue that to Judge Brewer.
Why are we litigating over $3,000? Is this, does the result of this appeal bear on attorney's fees, or do you get attorney's fees either way under the offer of judgment?
Your Honor, the state gets attorney's fees either way, but it does bear on the issue of whether or not UT, the plaintiff, the insurer, is going to seek attorney's fees under the Florida statute because they arguably have a judgment now in their favor for $3,000. But we contend that we will get attorney's fees.
It couldn't have been $3,000.
Yes. So yes, attorney's fees are an issue here.
So if they prevail, they get fees under 627, 428?
They're entitled to it.
It may trump that, correct?
Absolutely, Your Honor.
So really what this is about is potentially attorney fees?
That's what it's about, Your Honors, potential attorney's fees, and also the fact that we now have a judgment that's entered, and there's absolutely no competent substantial evidence to support that judgment, but really the correct standard of review here is clearly erroneous, because these are not findings, disputed findings made by a jury that resulted in
The principle.
Absolutely. It was a judgment that was entered purely by the trial court, and she made faulty conclusions and inferences from undisputed documentary and testimony evidence.
Would you respond to UT's argument in their brief, which was throughout that on the preservation issue? They're claiming that most of your arguments were not preserved. Can you
Yes, Your
respond
Honor.
to that?
And that argument was directed at the joint pretrial statement, and I did concede that the words joint pretrial statement were never mentioned to Judge Waller, the trial judge. They weren't mentioned in our filing, they weren't mentioned at the hearing. Now, page 5 of the appendix to UT's brief does include a letter to Judge Waller. There was various filings that went back and forth before the hearing on the entry of final judgment, where we did quote the exact 371 number, basically recounting the dispute between UT and suggesting to the judge that this wasn't a good payment. But the preservation issue is whether or not we preserve the issue regarding the joint pretrial statement. And that's why if I didn't believe that that rose to the level of fundamental error, that when parties get together and reach an agreement on the issues to be tried and compliance with Rule 1.200, I believe that rises to the level of fundamental error, and that's why we're asserting an error in this case. But as far as the rest of the arguments, those have been preserved. The issues regarding the checks and the $50,000 and the $185,000 containing the identical information, type of payment, settlement, 5101 building, that could mean nothing other than payment on the building claim. It would also preserve the argument that Mr. Decker's testimony that at least $360,000 had been paid on the building claim, that was brought to the trial court's attention. So really,
5101, is that what it is?
that was a code that was on the two checks, Your Honor.
Is that the code for the particular coverage, or what is that?
That's the code for the building coverage.
Yeah.
But besides just that number of 5101, and if that's all that was on the checks, I could see maybe some ambiguity, but it says total payment, settlement, 5101
Right.
building. You can't get any clearer than that.
Right.
And those checks are both in the record. And also, as far as the preservation error, we did argue to Judge Waller that there was no conflicting testimony that at least $360,000 had been paid on the building claim. So those are really the only issues as far as preservation. I think UT is trying to make it seem ambiguous as far as what that $371,000 in the joint pretrial statement could represent, but it doesn't make any sense at all. It would be meaningless. The only reason they're even conceding $185,000 was paid was because a witness at trial testified as to that certain check. But that would render the $371,000 in the joint pretrial statement absolutely meaningless. Then there would be no agreement that any amounts have been paid on the claim actually at issue before trial. It doesn't make any sense at all. And I think UT is also trying to make it seem like, well, what could this $50,000 check represent? And they're pointing to various evidence. Well, it could be contents, it could be business interruption. Now, both those claims were settled prior to trial. What we do have in the record is a contract between the public adjuster and the insured 13 days after the fire, and it actually notes in that contract that their 15% fee would not apply to $156,000 that had been offered 13 days after the fire on the building claim, and another $18,000 on the contents claim, that they would not take their fee. So that's what we have, the evidence of what was going on at that time. So clearly, there were offers being made as far as the building claim. And I also understand that fundamental error is rare and it's the exception, but this court doesn't have to reverse and enter judgment in favor of CHUBB just based purely on fundamental error. We also have our errors as far as the failure to accept the unrebutted testimony and documentary evidence of the checks and the payment of the $360,000 MKA estimate. But then we also tried to remedy this error after judgment was erroneously entered, and we filed our motion to alter or amend judgment. And in instance, we attached an affidavit of the person at York, the independent adjuster who actually supervised the issuance of the checks, and her unsworn, unrebutted affidavit made it abundantly clear that those checks for $50,000 and $185,000 were both issued in payment of the building claim. There was never any response filed to the motion or alter or amend. There was no motion to strike the affidavit, and there was no hearing held. It was summarily denied by the trial court. So again, that error is clearly preserved. That evidence is in the record, and it was unrebutted. So, I mean, basically, at this point, we have, the only objection we have to the reversal of this judgment and having judgment entered in favor of CHUBB is the fact that one fact witness was not able to identify the various components or checks making up an unrebutted claim or payment on the building. And that's simply insufficient. And so this case definitely warrants a reversal of the judgment and a remand to have judgment entered in favor of CHUBB. And if the court doesn't have any further questions for me, I'd like to reserve the rest of my
All right, you
time.
got almost 10 minutes.
Okay, thank you, Your Honor.
Thank you.
May it please the court. My name is Bill Wagner. I represent UT Investments. Judge Bradley, you put your finger right on my case. It's a preservation case. Here is what they argued below. Remember, we're going to have the judge messed up, right? Here's what they argued below. Mr. Brown. So with respect to this case, we're going to remand. The damages were $188,000 and change, and we have two checks which on their face reflect payment on the building of $235,000. They find this step on appeal, and they say this step was a stipulation of building damages. But they never argued that to the trial judge. They argued to the trial judge again and again and again that the total payment for building damages was $235,000. They filed their own proposed final judgment. It says, it's a judge that plaintiff, UT Investments, is awarded $188,000 in building damages, and no further amounts are awarded in building damages by the jury. Defendant previously paid plaintiff $235,000 for building damages.
So wasn't the issue that was framed for the jury by the stipulation, as I had previously read, the insured has presented a claim to CHUBB Insurance Company for a loss of the building in the amount of $1,030,349.13. CHUBB has paid the insured $371,455.76, applied the policy's $5,000 deductible, and deducted depreciation of $33,584. And then there was an agreement between the parties that as to 12 rooms.
Right.
And that the damages of those 12 rooms was the $188,734.18. But at the trial, but that didn't resolve all the issues at the trial, because the jury still had the roof.
Sure.
And there was a disagreement over what rooms were damaged and what rooms weren't damaged. So the jury has the stipulation, and they're looking at an amount between $371 and some change up to $1,030,000. And they decide, based on the evidence that they heard, that there was nothing else that UT was entitled to get,
Okay.
that they had been adequately compensated for whatever damages. So the $188 wasn't the total amount.
Right.
I mean, so the joint stipulations, so the purpose of them for the rules of civil procedure is to bind the parties and
Right.
to bind the issues. So
Sure.
how is it that when you've got a joint stipulation and argument by counsel, that the jury's got to determine between, is there something between 371 to 1.3 that the damages issue that CHUBB has paid $371,455?
Okay, well, you formulated a pretty good argument to make to a trial judge. So I want to make to the trial judge. They went to the trial judge and they said, Judge, this is a simple case. This is post-jury verdict set-off. Okay, it's pre-judgment, post-jury verdict set-off. They filed a half dozen pleadings. They had a hearing on it November 22nd. They starts at page 5,030 of the record. And they made a case. They presented their case and they said, Judge, here's what we do. We take two checks. One $185,000, and we add a $50,000 check to it. That's greater than $188,000. That's our case. They didn't say to the judge, and Judge Barber, under the pretrial stipulation, to determine what exactly that stipulation says, because I assert that it's not just for building damage. It's certainly vague. It's based on a public adjuster estimate from ICH, Insurance Claims Help, where they include everything in their estimate, including contents, furniture, everything else.
What's misleading about it? I mean, the insured has presented a claim for loss to the building in the amount of, CHUBB has paid this amount.
Right.
I mean, what's misleading, especially when the jury's already been told that the issues regarding the contents and business interruption have already been settled.
Right, and I think that where we can look to establish the ambiguity is to CHUBB. I mean, CHUBB is arguing to the court, unambiguously and repeatedly, that for building damages, they paid $235,661. Why did they argue to the court that, Judge, why are we even here? We have a joint pretrial stipulation that we paid $371,455 for building damages, because that's what CHUBB did. CHUBB told the court we paid $235.
Well, that's still more than 188. The argument has been consistently that no additional payments were owed.
I agree, and let's talk about why no additional payments are owed. We have a stipulation during the course of the trial that even if there was a zero verdict, the minimum to that zero will be $188,000. That's the stipulation that's reached during the course of the trial. Now, we put in our evidence, right? And the evidence establishes a check for $185,000. And it says on the check, it says, quote, building damage, close quote, right? Now, there's another $50,000 check that's put in evidence. It says, quote, advance on fire loss, close quote, okay? Now, let's say their story is, based on this chapter, he said that we paid all of our building damages based on our report from MKA. That's what we based our building damage payments on. Is that possible? No, it's not possible, and I'll tell you why. This advance on fire loss check was written in November 2009, which is 3 months before the MKA estimate ever existed. And what did they have in November 2009 when they wrote the check? What could they have based it on? Well, they had their own adjuster's report from August that had everything in it. They had an ICH estimate that had all elements of damage in it. And they had an insurer who was shut down analyzing documented losses for business interruption. So they're the ones that are asserting set-off. It's their turn to assert set-off.
But when you agree to the issues to be tried, and you come to an agreement that you're claiming $1 million and some change,
Right.
we're claiming we paid $360 and some change. I mean, do we get down to a due process issue at that point? Because, and then you agree to 188 during the middle of the trial. You agree to the 188.
Right.
And, I mean, going back and looking at the arguments, I mean, even the opening statement by UT's counsel, I mean, it seems to me that there's no issue over this $360,000 amount and what that was paid for, at least in the mind of counsel at the time of the trial, and to try to figure out what's going on. It just seems to me that if that issue is framed, then, and the jury has said, you don't get any more money,
Right.
what's there to set off? They paid $360, the agreement was $188, they paid more than the $188.
Great argument. You're making a real argument that should have been presented to the trial judge, but it wasn't presented to the trial judge, and I'll tell you why. I don't accept that the stipulation, we're making an assumption about the stipulation, that the stipulation says it was $371,000 for building damages. They had fire in the building. They had fire in the building. They had 3 elements of loss for the fire in the building. They had building damage, they had contents, they had business interruption.
This is a trial about building damage.
Correct.
This is not a trial about contents. This is not a
Sure.
trial about interruption. So what would be the point of a joint stipulation that sets forth amounts paid if we aren't talking about the issue to be tried? which was building damages, because they paid more
Right.
than $360,000.
And if you're the trial of fact, and I was trying this case, which I didn't try the case, but if I'm trying the case and you're saying, Mr. Wagner, tell me about the stipulation, I could make arguments about it, you could make a ruling as the trial of fact, and then I would take it to the 50CA and address whether or not that was a proper ruling. The problem is, they're going to say, Judge, we've got a stipulation that we paid $371. That's not what they say. What they say is, we paid $235. That's what this case is about. In order to get set up, we paid $235. It's $185 plus $50. That's our case. Well, they're kind of stuck with that case on appeal. And what this case is about, as Judge CHUBB briefly mentioned early on, is it's about the $50,000 check. And during the November 22 hearing, which followed 2 months of everybody filing claims and making arguments about the composition of the final judgment, during that hearing, they said, Judge, here we go, check 1 and we got check 2. Check 1, says, building damage, but we said that code 5101 means building damage. It doesn't mean contents of the building, it doesn't mean business interruption, it means building damage, right? We have no evidence that that's true. We do have evidence now. We have evidence in the post-judgment motion to amend the verdict. We now, for the very first time, have an adjustment that says 5101 means building damage. And that's why we wrote this judgment amendment, which is basically a second for the apple. No cross-examination possible. All it is an affidavit, which is hearsay, that they filed after the judgment was already entered. All right, but at the trial, in front of the trial judge, they don't say, Judge, we enforce our pretrial stipulation, we pay pursuant to the pretrial stipulation $371,455.76 for building damages. They didn't say that. They say they paid $235 and it's about the $50,000 check, and I agree. So, they make arguments. They present the 2 checks to the judge. The judge reviews the checks. The judge looks at the checks and says, I don't find sufficient evidence that this $50,000 check is for building damages. Mr. Wagner testified at trial. I have no idea what the $50,000 check mentions, but he does say this. I approved payments for building damages based on our MKA estimate. I approved payments for building damages based on the MKA estimate. When was that done? 3 months after the check was written. 3 months after the check was written.
And the check was written for an advance.
Sure, and the only concrete, measurable loss my client was suffering when the check was written, they didn't even have the estimates yet from the insurance company. They didn't have the MKA estimate in, but we knew they were suffering from business interruption.
And they got paid for that separately, did they not? Ultimately, they got a check for business interruption.
Absolutely.
The 50,000 could have been on business interruption.
Exactly, Judge. It says
I mean, I guess at some point they figured out what the loss was, correct? Did they take out 50,000?
I don't know.
No.
See, the advantage of being an appellate lawyer that didn't try the case is able to look only at the same record you look at.
Yeah.
And I don't find the answer to that question in the record, Judge. But I think to myself, okay, what makes sense? What makes sense? Okay? It says advancing material loss. Well, that's likely all 3. I mean, really, it's likely advancing all 3 categories. But look, when you're talking about set-off, the parties involved, in this case it's CHUBB, they have to prove which bucket that the checks go in. Because if you pay me $1 million on business interruption, you don't pay me $1 on contents and I get a verdict for $1 on contents, I've got a verdict, right? Don't have to pay me $1 million on something else. If you want to set off that dollar, you have to set in that bucket to offset it. And that's what they did. That's what they did at trial. In front of the trial court, they said, we're going to send checks. We're going to show you exactly where they go.
And they also talked about at trial that they did not admit into evidence the actual check, but they talked about this other check in the amount of $135
something.
$136,000.
Yes, that's what the check represents, and nobody else can either. Because
But if you add 50,000 plus the 185,000 plus the 30-something thousand. It
Sure.
comes out to, because I checked the math, it comes out to the exact dollar
Sure.
that was in the joint stipulation.
Yeah, so let's tell the trial judge that. Let's tell the trial judge that. Look, I gotta calculate. Let's say because then the judge can say, okay, well, I'm not going to the stipulation, and I'm going to agree with Judge Berger. I'm going to agree that this unambiguously means that the 371 is billing damages, and I'm going to take out my calculator, and I'm going to add up all three of these checks, and I'm going to get the 371, 455. Okay? But you gotta argue it to the trial judge. You so what was she asked to do? Was she asked to do that? No. Was she directed to do that? No. What they told her to do is exactly what she did. They said, CHUBB said, I want you to look at two checks, Judge. 105 and 50. 105 and 50. And when you have 50, that's therefore, we don't have anything. And the judge said, sorry, but I will find that we established that the 50 was in the billing damages bucket, therefore you have $3,000. That's the case. It's really hard to find that. And they come up with some really interesting arguments.
Can you address their argument, because you both have competing standards of review?
Sure.
Can you address their argument on the, that we're to apply the clearly erroneous standard of review based on everything that happened at the trial, that the court looked at it erroneously?
Sure. Well, we have to establish our elements to get there. One of them is that we're on undisputed facts, and I don't accept the word undisputed facts. They say $50,000 is for billing damages. I say no, it is not. And the judge agreed with my client on that issue. So we don't have undisputed facts. How do we know these facts? Whether or not their evidence was established to satisfy their argument that the $50,000 check was for billing damages. CSE. That's a CSE question. I'm not moving forward. I'm not moving forward in the second issue, so I have no burden of proof to establish that the record is supported by CSE, right? Because I'm the non-moving party. Now, there's a denial of due process, okay, which constitutional issues are reviewed de novo, but they're already denied due process because they express total shock at the composition of the final judgment, okay? Well, trial commenced. We have a flurry, mostly CHUBB-induced flurry of pleadings filed in September and October. Everybody is setting forth their positions about the set-off issue, okay? Including an unambiguous argument from CHUBB that it's 185 plus 50. That's the case, right? Then we go to hearing, represented by counsel, and everybody makes their arguments. They put out the checks, they show the judge, and they express total shock at the outcome of the final judgment. Okay?
And never argue about the stipulation.
Never argue about the stipulation. They never argue. In fact, they talk about, Mr. Berger testified unambiguously and in an uncontroverted manner that he paid $360, which is not $371, by the way. Okay? So he paid $360. But they've not established where that $360 goes. He said, yes, we paid $360. But
That's the MK, that was the amount with MKA. Because that's basically the number that.
Yeah, I can't make the numbers add up. I mean, if you add up the checks, you get the different numbers, 402 and 360, and then you get the 371. And the bottom line is, look, put yourself in the trial judge's shoes. Trial judge is sitting there, she's going, okay, lawyers, prove my case. What am I deciding? What is she really deciding, lawyers? CHUBB's lawyers say, and UT's lawyers say, judge, it's a set-off. We say 185 plus 50 is greater than 188, therefore no judgment. UT says, judge, it's 185 and 185 alone, because they don't pay the $50,000 check. This is a $50,000 check case. Because the judge can't make a decision that she's not asked to make.
Was it inappropriate for the judge to consider the affidavit?
I think it was, Judge, and I'll tell you why. Which is, a motion to alter or amend the judgment, is not intended to allow the parties to reopen the evidence, okay? For example, if the judge made an oral ruling and the actual written ruling is different, we file a motion to alter or amend the judgment. If it was based on mutual mistake, we can file a motion to alter or amend the judgment. What we can't do is say, Judge, we realized when we got to the hearing that we didn't know what that $50,000 check was about, and that no one testified that we had covenant, Judge Jacobus. So everything was really
Both checks in the same code, though, correct?
Sure, it's the same code, but I don't know if that code means that's borrowing assets. I don't know if it means it's when we do advances we put it in there. We don't know. What we're doing now is we're trying to put that affidavit in, because the affidavit filed post-judgment says that $50,000 is only for building damages, okay? So, our position is this: you had your opportunity to try your case.
They used the affidavit at the set-off hearing, but they couldn't use it the second time.
I think that's why we do set-offs post-jury all the time, right? So you come into the hearing, and you say, I got no witness to testify on the case. That's fine. I don't see any problem with that. And the problem is they waited until after the judgment was entered before they filed their affidavit. That's the problem. We just think it's a 185 plus 50 case, and they did not establish, the judge found that they did not establish that the $50,000 was for building damages. Any other argument they made was not preserved for appellate review.
All right, sir.
Thank you.
Thank you. All right, you got 9:42 left, counsel, your rejoinder.
Your Honor, counsel never addresses that both of these checks say type of payment, settlement, 5101, building.
His argument is that no one knew what that meant.
The checks on
101 building, in other words, no one knew what that meant. Except by your affidavit, I suspect, but...
The checks were admitted as joint exhibits.
I understand.
For what they, yes, and this, Mr. Deckers at trial did not know what the individual component checks were making up the $360,000 estimate. He testified that he directed any undisputed amounts be paid to that $360,000 estimate. That meant the previous payment of the $185,000 and the $50,000. What's left? It's the $135,000. All you have to do is add up the math, and this is all in the record. And also, Judge
Yeah, but that wasn't, it was not articulated clearly at the hearing on the set-off. And nobody said, we don't need to be here, there was a joint stipulation, this is the amount that was paid, look at what counsel even argued in his opening statement and his closing. I mean, these issues were all framed, this was all agreed upon ahead of time, that this was the amount. I mean, arguably, you didn't even need to put on evidence of any of the checks during the course of the trial, because there was a stipulation as to the amounts. Yet you did, and the witness that testified about the $50,000 check wasn't able to testify what that went to. So you're stuck now with what that witness said, and you got the judge at the set-off hearing that's not informed about the joint stipulation, or reminded, I should say, about that stipulation that was actually read to the jury. And you basically say you got a $50,000 check and the other $185,000 check, and you have a witness that testified couldn't say where that $50,000 check went to. So how is, when the judge is not presented with which would be, I think, a winning argument on appeal, and a winning argument at the hearing, and the judge wasn't presented with that argument, and was just now faced with recalling the testimony of the witnesses with regard to that $50,000 check, how is her ruling that the $50,000, when there was not any evidence with regard to what that notation meant on the check, how is her ruling clearly erroneous?
Your Honor, I agree. Nobody reminded Judge Waller, the trial court, about the joint pretrial statement at the hearing, but I would refer to page 5 of UT's appendix, an answer brief, which is a letter to Judge Waller dated September 7th, 2011 by CHUBB's counsel, where it says, in an email sent August 30th, 2011, we provided counsel for the plaintiff with a copy of the first draft of defendant's proposed order of final judgment. These went back and forth. And in that first draft of the final judgment, it says it is a judge that plaintiff UT Investments is awarded $188,734.18 in building damages by agreement of the parties, and no further amount was awarded in building damages by the jury. However, as the defendant had previously paid plaintiff $371,455.76 for building damages, the amount paid by defendant to plaintiff before trial, So that number that was in the joint pretrial statement, it was provided to the judge. I agree, she was not reminded of it at the hearing, but it wasn't like that wasn't out there in the record and in this letter to the judge with the first proposed final judgment. And also, counsel doesn't, there was more than just these 2 checks. There was also the testimony that the $360,000 MKA estimate was paid. That was never disputed. That amount was paid. Now, whether there was 1 check or 20 checks making up that payment, is that really material if no witness is disputing that that payment was made? And that was made.
That argument was made?
That argument was made. Trial counsel at the hearing before judgment was entered, that argument was made. So it wasn't just the 2 checks.
What was it now, 360?
360 was the estimate, and there was no dispute.
And that report was in evidence?
Yes, Your Honor, that report was in evidence. There was no rebuttal testimony that that amount wasn't paid, and that argument was made to trial counsel. And notice how that was never addressed by counsel. They don't address that. They don't address all they address on those checks is the detail section, which was like a memo on a personal check where you'd write rent or utilities. That's the only section they address. They don't address where it says type of payment, settlement, 5101, billing. They both say billing. Again, admitted into evidence without objection.
And at the hearing on the set-offs, there was argument that $360,000 was paid.
Absolutely, Your Honor. That's in the record, that's on the transcript. So even if you don't agree that the failure to enforce a joint pretrial statement and agreement that narrows the issues to be tried, that doesn't rise to the level of fundamental error, and even if you dispute whether or not those checks that say settlement 5101 building don't mean exactly what they say, even if you reject that, there is no rejecting, there's no basis for rejecting that you have a witness that testified that an estimate for the building at $360,000 was paid. That argument was made, and it was rejected by the trial court, and that was error. And that was based on, again, clearly erroneous, because there is no conflict in the evidence. It is what it is, and it was erroneously ejected. And for that reason, we request that the judgment be reversed and be entered in favor of CHUBB.
Okay, thank you for a well-argued case, counsel. All right, the court will call